Hello, everyone. This is Matthias Matthiesen. I'm the Director for Privacy and Public Policy at IAB Europe. Your host today for this IAB Europe guest webinar put together by the Education and Training Committee. Clearly, we're having some technical issues. Sorry about that. Your ears permitting, let's continue. So this webinar, entitled GDPR 1 Year On, Lessons Learned, is given by Philip Weiss, the Director of Marketing at EUbenda, and Abby Clement, the Head of Content of EUbenda. They're both members of IAB Europe, particularly the IAB Europe Education and Training Committee, for putting this together. And they will, for your benefit, review some of the key aspects of the GDPR before discussing what in their experience has shown to be some of the common pitfalls. Later, we will have the opportunity for you to ask questions, or actually, there is the opportunity for you to ask questions throughout this webinar using the GoToWebinar control panel or your questions options there. So as you get questions, please feel free to just type them down and submit them. And our guest speakers can either decide to pick them up on the fly, or we will pick out a few of the questions that people have asked during the Q&A portion of the webinar. So before we continue, and I'm sure this won't be necessary, but just some common disclaimer is that this is a guest webinar, and we think it will be very valuable for you, and we'll probably regret saying this, but the views and positions expressed here, unless they're presented by me, are not necessarily the views of and positions of IAB Europe. They're those of EUbenda, but I'm still very confident that you will get great value out of this. So without further ado, I'll hand it over to Philip to take it from here.
Yeah, thank you, Matthias. Thanks for having us, first of all, and thanks for the nice introduction. So basically, we have prepared the following agenda for you today. So we're going to talk a little bit about, I'm sorry, Matthias, I'm getting a bit of an echo from your side. Maybe if you can mute for now. Yeah, okay. So as I was just saying, so thanks again for having us. This is the agenda for today that we've come up with. So we're first going to give you a very brief GDPR overview, key aspects. We're going to take this, do this very short, because I'm sure quite a few people on the call today, on the webinar today, will have some knowledge in that extent. And then we later going to talk about GDPR common pitfalls, which is basically what we've learned over the last year working with a lot of clients in that area. So what can go wrong potentially? And we also obviously we are quite looking forward to the Q&A in the end. So once again, as Matthias already said, please post all your questions anytime. You don't need to wait until the end, and we're happy to answer them. Okay, so I think we can go to the next slide here. Okay, yeah, this is just the overview. So if we are getting, if we're going forward here, so essentially, as you may know, at its core, the General Data Protection Regulation specifies how and when personal data should be lawfully processed. So that is the essence of it in short. And as you may also know, it became fully enforceable on the 25th of May last year, which is why we're having this webinar today, because it's pretty much almost exactly 1 year after. And the idea is to strengthen, obviously, data protection for all the people whose personal information fall within its scope, and giving them greater control of their personal data. Okay, moving on. Moving on to the next slide, exactly. So we wanted to point two more things out here on this slide. So what you should know is that personal data under the GDPR refers to any data that relates to an identified or identifiable person. Now, the difference between the two is that essentially identified means it is directly linked to a physical person, whereas identifiable means that it is information which, combined with other information, can lead to the identification of a person. So there's a bit of a distinction there. And also under the GDPR, personal data may only be processed if there's at least one legal basis for doing so. Now, we're going to talk more about legal basis later, because it's essentially one of these core terms of the GDPR, which tends to be confused to some extent. Okay, so if we move to the next slide. This is also something which some of you may know, because it's got very popular in the press as well. I just wanted to share a little bit of more background here in terms of consequences of non-compliance. So the fines can be up to 20 million euro, or 4% of the annual worldwide turnover of the given company, whichever is greater. And also there are further sanctions such as official reprimands, data protection audits, and liability damages. And actually these audits that we mentioned here can have quite serious consequences. So what that essentially means is, if authorities decide to put a ban on all the data that you as a company collect, this can obviously be really damaging, since you can lose a lot of valuable data that your business organization relies on, essentially. Okay, so if we move to the next slide here. Now we want to talk a little bit about the GDPR key aspects, and essentially Abby is gonna talk about this.
Hi everyone. So just so that there's no confusion, Philip and I are in the same location, so we're just kind of sharing the microphone. So we can jump right into these if we move on to the next slide. And the other. So we're going to go over the legal basis of processing data. So the first one, which is obviously quite well known, most popular, is consent. And this is where the user has given consent for one or more specific purposes. The other one is contractual requirements. And this is where the processing is necessary for the performance of a contract in which the user is a participant, or necessary in order to take steps requested by the user prior to entering the contract. So one example of this could be, of course, this is depending on the context. Let's say you have a help chat on your homepage so that people visiting might want to get an idea of your service. So obviously, if they're entering your chat, there's going to be some data that's coming in there. So this is one example of where it is possible to be relying on contractual basis. Of course, all of this is situational. The next is the legal obligation, and this is where the processing is necessary for the fulfilling of a legal obligation to which the data controller, likely you, is subject. The other legal basis is vital interest. This is where the processing is necessary for the protection or the protecting of vital interest of the user or another person. There's public interest. The processing is necessary for performing a task carried out in the interest of the public or as contained under the official authority given to you, the data controller. And then lastly here, we have legitimate interest, which I'm sure you've also heard come up quite a bit. And this is where the processing is necessary for the legitimate interest of the data controller or third party, except where overwritten by the interests, the rights and freedoms of the user, in particular where the user is a child. So we're going to actually touch on this a little bit later, because there are a couple of things to keep in mind here if you're relying on something like legitimate interests when it comes to the user's right to object, but we'll get into that a little bit later. So if we can just move on to the next slide. So this is just a note that's really important. The legal basis shouldn't be just picked at random, as they need to legitimately apply to your situation. If for any reason you're challenged or something on that, you're going to need to be able to actually demonstrate that the correct legitimate interest does actually apply. So when it comes to evaluating whether or not a legal basis outside of consent can apply, we suggest working with a legal professional, as determining the correct legal basis is very, very important, and it can be quite difficult. And of course, furthermore, there will always be data processing activities where consent is the safest, best, or only option. And that might come up a little bit later, once again, when we're talking about user rights. But consent is one of those that you can rely on, where you're actively getting consent from the individual. So it's one of, in some cases, the safest option. So if we can just move on to the next slide here. So we're just going to go back.
Yeah. Okay. So I'm going to cover the next 3 slides, and then we're going to switch back to Abby. So this slide is about consent. So essentially, the most important points here in this regard, we already summarized them for you for this slide. So the thing is that consent, as you probably know, must be affirmative, informed, and freely given in order to be considered valid. So this is really, really important, the bolded part here that we put. And then also the mechanism for acquiring consent should be unambiguous and involve a clear opt-in action. So what you cannot do is the what you may have seen online, these pre-tick boxes, and also similar opt-out mechanisms. We're actually going to have an example on that later on when we talk about the common pitfalls. We're going to show you a practical example. Also, the regulation gives users a specific right to withdraw consent. And the point is here that it must be essentially as easy to withdraw consent as it is to give it in the first place. Okay, and then where the processing, this now applies as you as a company or as an organization, where the processing based on consent, you must also be able to demonstrate that valid consent was collected in the first place. Okay, so now if we move on to the next slide, we have prepared 5 users' rights for you here. These are not obviously all of them, but essentially we made a selection here for you before we then take this as a foundation, moving on to the common pitfalls. So essentially, the first 4 ones you see here. So the first one is the right to be informed. And that means that organization must provide users with information about the data processing activities they carry out in relation to the user's personal data, of course. Then the right to access. So users have the right to request and access their personal data and information about how their personal data is being processed by the processor, the data processor. And then we have the right to rectification, which means that users actually have the right to have their personal data rectified if it's inaccurate or incomplete. And then finally here, the right to erasure, which kind of goes in line with the points before. So when data is no longer relevant to its original purpose, or where users have withdrawn consent, or where the personal data has been unlawfully processed, users have the right to request that their data be erased and all dissemination of that data ceased, essentially. Now, we have one more user's right on the next slide, which requires a little more of explanation. And that one is the right to object. So users have the right to object to certain processing activities carried out on their personal data. So what that means is the user can object to the processing of all the data whenever the processing is based on the controller's legitimate interest. So this is what Abby talked about before. Or the performance of a task in the public interest or exercise of official authority, or for purposes of scientific, historical research and statistics. Now, the last point here is the important one, because what we pointed out here is that the user actually has to state a motivation for their objection, unless the processing is carried out for direct marketing purposes, which I guess is very relevant to our audience today, in which case no motivation is actually needed to exercise this right. Okay, so this was sort of the foundation. Now we're gonna essentially talk more about the learnings we made over the year, and Abby is gonna cover that part while I'm gonna keep an eye on the questions. So just to remember that you can post your questions anytime. We've seen that we have already received a few, but please do post more if anything comes to mind.
Okay. So we can just jump directly into these by going to the next slide. All right, so the number one pitfall here, and this is something that we see quite often across all of our clients, and they span different countries. One of them is assuming that the GDPR does not apply to you just because you're based outside of the EU, or if you're based in the EU but happen to have only non-EU based users. So just to clarify, there are three scenarios more or less where the GDPR can apply. One is where your base of operations is in the EU. So that takes us to the second part of the question, which is even if you do have users that are completely outside of the EU, so let's say you're an EU-based business and all of your users are in the US and you're only targeting them, because your base of operations is in the EU, you do fall under the scope of the GDPR and you will have to extend GDPR protections to all of your users. The second scenario is where you are not established in the EU, but you offer goods or services to people in the EU, even if that offer is for free. So let's say you're based in the US, you have a website that's accessible by everyone, including people based in the EU. Again, you would fall under the scope of the GDPR and you'd be required to extend the protections of the GDPR to your EU users. And lastly, where you're not established in the EU, but you monitor the behavior of people who are in the EU, as long as that behavior takes place in the EU. So this can apply to maybe running some analytics programs on your site or monitoring the behavior of people in the EU in any way. In those cases, even if you are based outside of the EU, you do fall within the scope. Now, the scope is quite wide-reaching, And generally, this therefore means that the GDPR can apply to you whether you're based in the EU or not. And once again, there are very few cases where you would have zero responsibilities under the EU, unless you're completely based outside the EU and you're actively blocking people from the EU from accessing your site in any way. Generally, it makes a lot of sense to pay attention to what the requirements are. Okay, so next, just to expand here, the second pitfall that we've seen quite a bit, and this one is very, very rampant, actually, is failing to maintain proofs of consent and not being able to demonstrate that valid consent was collected. So just to go over, of course, because consent under the GDPR is such an important issue, it is very important that you keep clear records and that you're able to show that you've acquired valid consent. Should problems arise, the burden of proof lies with you. So keeping demonstrable proof is both vital and required. So just to go next here. Now, these records should at least include, and this is sort of a base example of what we've seen, and based on recommendations, what you would need at the very least to sort of demonstrate that valid consent was collected. And just to clarify here, this example is based on an example listed in the Article 29 Working Party, as well as under the guidelines of consent, as well as the ICO's recommendation. So just to get back to it here, what we do have is who provided the consent, when and how the consent was acquired from the individual user. The consent collection form they were presented with at the time of the collection, and you can imagine why that would be important, so that you can actually show that the user was properly informed on your form and that they opted in, as well as which conditions and legal documents were applicable at the time when the consent was acquired. And by legal documents here, we're generally talking about things like your terms and conditions and your privacy policy and that sort of thing. So let's go on to the next slide. So this is another one. I mean, they're all quite popular, but this is one of those really base things that can really cause problems that extend across all of your processing, and that is confusing the roles and the responsibilities of the data controller and the data processor. And we've actually found quite a few people that were confused as to whether or not they were the data controller or the data processor. So just to clarify with some definitions here, the term data controller means any person or legal entity involved in determining the purpose and ways of processing the personal data. And the term data processor means any personal legal entity involved in processing personal data on behalf of the controller. So if it's in your interest, if it's your organization and you are making use of and determining the purpose of processing that personal data, you are the data controller. Ultimately, the data controller bears the responsibility, once again, for the user's data that's processed, and therefore knowing which role applies to you is vital. And these roles are not based on choice, but rather an objective assessment. So getting this wrong can really lead to severe fines if you're found to be in breach. Also, just a quick mention here to keep in mind that when you're working with data processors, you want to have a data processing agreement in place. This is required. It governs the relationship between the controller and the processor. It also sort of protects both parties in some way, where you can ensure that the processor that you're working with is making a commitment that they will process data on your behalf in a compliant way. All right, let's move on to the next slide. All right, so there's a little example right here just to make it clearer in case it was confusing. So let's say an e-commerce company collects users' personal data and stores it via a third-party cloud service. In this scenario, the e-commerce company is the data controller and the organization running the cloud service is the data processor. So this was just to further illustrate the point that we covered on the other slide. Okay, so now we can move on to the fourth pitfall, and that is failing to create and maintain records of your processing activities. Now, this one is really, really common to be misunderstood. Most people have at least come across the requirement to maintain records of the processing activities, but in many cases, they think that it doesn't apply to them. And we're going to go through why as well. So the GDPR does require that both data controllers and processors keep and maintain full and extensive, that's direct quote, up-to-date records of their data processing activities. The records of processing activities must be in writing. While both paper and electronic forms are acceptable, it is best practice to use an electronic method of record keeping so as to facilitate easy amendments. Now, the must be in writing here doesn't mean that you have to physically write it out. Obviously, it just means that simply keeping an audio record of it would not be enough. So moving on to the next slide, we're going to get into why people tend to get confused. So full and extensive records of processing are expressly required in cases where the data processing activities are not occasional, or where it could result in a risk to the rights and freedoms of others, or where it can involve the handling of special categories of data. So this is things like health data, information in regards to children, things in regards to sexual orientation, things like that, or where it is carried out by an organization that has more than 250 employees. Now, this last point is kind of one of the major reasons why a lot of people get confused. They go, okay, I have less than 250 employees, I should be exempt. And this is not the case. So all of these are or situations. So where any one of these applies, you're required to keep these records. And the number one point here is where the processing is not occasional. And by and large, if you have some sort of website that you're processing this data to, or you're having just regular business operations and processing user data is central to the things that you're doing, your processing is not going to be occasional. It's a very hard case to fall into where the processing is occasional. So therefore, these cases, it effectively covers almost all the data controllers and processors. So let's move on to the final pitfall here. And this is failing to collect separate consents for separate purposes. Very easy trap to fall into because sometimes it can seem really convenient to bundle everything all together in one. So we're just going to start with an example scenario. A website owner uses a sign-up form that allows users to consent to receiving emails for both product updates and third-party offers using a single opt-in mechanism like a checkbox. Now, in this scenario, the website owner, the data controller, is failing to comply with requirements as the consent acquired must be specific to a singular purpose. So we can just go to the next slide here to expand on that point. So in cases where you want to send more than one type of email to your users, you're required to get an additional consent specific to those uses, as you must have multiple consents for multiple purposes. This doesn't necessarily mean that you must use a separate form for each purpose, but it does simply mean that you should give the user the opportunity to actively consent to each purpose. And we're going to go to an example in a second, but all this means is that you can use something like multiple checkboxes on the same form where you inform the user of the various purposes that you have in mind for this particular piece of their personal data. So now we're just going to give you a practical example. Yes. So this is an example of how this can be done correctly. on the same form. So contact permission, and as you can see here, we have, yes, I would like to receive a weekly digest of the consent posted to this blog. And then you have a separate one for, yes, I agree to receive product information and offers from this blog. And as you can see here, the user is informed that these are optional and not mandatory for the functioning of the service or anything like that. And they are unchecked, which means that the person can actively opt in. And that brings us to the end of the 5 most common pitfalls that we've seen sort of stretching across various companies of different sizes and countries. So I guess we can jump directly into the Q&A.
Yeah, Philip and Abby, thank you so much for presenting there. Please feel free to pick out some questions you really feel like you want to answer yourself, but I'll just get it started here because I think there is a great question by Barbara Radon, who asks if in the context of targeted advertising, a third party needs to be named in a consent text, or if it is enough to refer to a category of the third parties.
Okay, just taking a look at the question here. Okay, so you have 2 separate things here. One is you need to have your banner, depending on what you're talking about. So I'm guessing you're talking about cookies here. So you need to inform the user. You have to disclose about third parties, the purpose of the advertising as well. And you should, by and large, name these third parties. Now, you have various points where this information would be included. One would be your privacy policy. And this usually also applies to if you have sort of third-party software running on your site, you have Facebook share buttons, or something like that, you're using an externally hosted contact form, you're going to need to declare those in your privacy policy. Now, your cookie policy can be considered a cookie dedicated portion of your privacy policy. And there you want to also list things like the category of processing and the category of the purpose of the processing and things like that. Depending on how you're handling that in your banner, you would have an extended section where you can also list additional details. But the point is that the user does need to be informed about the actual third parties that are processing their data, generally speaking, when you're looking at advertising.
Yeah, if I may add to that, the GDPR actually says in order to meet this information requirement of informed consent, at least the purposes and the controllers of the data need to be known. And we've seen that the CNIL, for example, in its recent enforcement at the end of last year, has deemed consent not to be informed, even though information about the exact third parties was present, just because it wasn't present early enough in the process. So not only do you need to have it somewhere on your privacy policy that if the user clicks through enough times, they can finally find it, you actually need to make it available at most 1 click removed from the consent request. So there has to be like a link in the initial layer of your consent request that says, here are the third parties that will be relying on the consent.
Exactly. So if you have a link directly to your cookie policy and you have that information immediately available, the link to your cookie policy should be on your banner and, as Matthias said, accessible within 1 click.
Cool. Here's another, I think, great question from Mr. You or Miss, I guess. You don't need to know. It's a pseudonym, I think. Is asking about the concept of consent being as easy to withdraw as it is to give it, and sort of noticing that there is a widespread practice of cookie consent that basically says you can consent by clicking the I accept button, but then instructs users to go into their browser and delete specific cookies in order to withdraw their consent, and whether you think that is compliant with the GDPR.
Okay, so the thing here is that there are sort of two regulations, well, two sort of pieces of law at play here, where there's also the e-privacy directive, soon to be regulation, that also applies and gives some specific information in regards to cookies. Now, it's with it being a directive, of course, it's left up to the individual member states to put the actual law into play in regards to their specific country, but they're all following the same general guidelines. And one of these is that the actual mechanism. Now, of course, this may or may not be the most convenient, but the actual mechanism for rejecting consent doesn't have to be hosted directly on site. So it is allowed for the user to have access. Of course, they must have all the information and have direct access to the third parties and their privacy policies, but they can manage their cookie preferences via the browser. Now, of course, what's required there via that standard and what is the industry standard for managing cookies, there can be some differentials there. It is obviously more convenient to allow the user to be able to simply click on something like a reject all button or something like that. But the implementation is by and large left up to you as long as it falls within the scope of the applicable law. I don't know if you want to add anything else, Matthias.
Yeah, so I would just say that there's two things. Like, you want to distinguish between rejecting as in not consenting when being asked. That is different from withdrawing consent, which is after you have already given consent. So while the law doesn't require that it is as easy to refuse consent as it is to give it, it does require that it is as easy to withdraw it as it was to give it. And I would say that if you can consent something with a single click, then a bunch of clicks and needing to delete cookies is not as easy to withdraw consent as it was to give it. So I would say that's probably not compliant with the GDPR requirement for consent or the withdrawal of consent, which is the requirement for consent in the e-privacy directive.
Sorry, I just wanted to jump in here real quick. So I saw different people asking if there will be a recording. So yes, there will be. I guess, Matthias, this will be emailed a few days after this webinar, or
2 hours after, as far as I know.
Okay. And then there was another question which I saw quite in the beginning. Someone requesting that, which we obviously cannot do in this webinar today, but someone wanted to see how our solution actually does this in practice. So for any product related things, we obviously cannot cover them today, but you could definitely join one of our own webinars, let's say. So the question was, how does the solution enable a website visitor to withdraw consent? Can you show this to us, please? Okay, Matthias, did you have other questions selected, or?
Yes, we have a nice pipeline of questions. So this is one from Mark Chatborn, who is essentially asking if small businesses are subject to the GDPR and if they will be forced to comply with it.
Okay, so the GDPR applies to any entity that falls within the scenarios that we covered earlier in the webinar. So whether or not you're a small business, if you're processing personal data of people based in the EU or you are based in the EU, you have to comply with all the requirements.
Thanks. This is a question from Tim Shallard, who has a little bit of a scenario. I'll just read that out. So if there is an EU-based organization that has US-facing URLs and EU-facing URLs, so for example, .com and .co.uk, if if that company felt that consent was the right legal basis for processing, would that company need to acquire GDPR level of consent from users also for the US facing part of their website?
Okay, so if you're an EU-based organization, yes, generally speaking, the GDPR does apply to you. So you'd have to extend the protections to your users, to all your users.
Even the ones who are not in the EU, yeah?
Yes, I mean, if it's saying that it's an EU-based organization,
Yeah.
so then it definitely applies to you whether or not your users are based in the EU.
So no point shutting down your EU-facing domains as an EU company to avoid the GDPR. Yeah? There is no escape.
Yeah, maybe just
All right, so
related.
here's a question from Lorenza Kerama.
If I can just
Who's
jump in
asking?
here. So,
Please go.
Yeah, so this is actually something we get a lot. So related to that, so because we obviously, as long as you have, let's say, in very basic terms, in English, let's say you're a US-based company and your website is in English, already that fact kind of makes it accessible to a large part of the world. So, you know, unless in your terms and conditions you kind of, you know, exclude European users from it, it sort of applies. So, yeah, just want to add that here.
And just to add that the terms wouldn't be enough. Like if you're, I mean, it's not exactly the user's question, but just to clarify again, in case we have US-based companies here, even if you're based outside the EU and EU people can access your site, you're not physically blocking EU-based users from accessing your site. You would have to apply the GDPR protections to those EU-based users at least.
Well, to sum up, the answer to the question is, if you are in the EU, the GDPR applies to you. You cannot weasel yourself out of that that responsibility. If you are outside of the EU, the GDPR will apply to you in certain circumstances. For example, because you're providing a service to people who are in the EU, which could be because your website is in English, although to be fair, that is a pretty weak requirement. But if you were to ship subscriptions to the EU, or you provided something more other than just making a website accessible to users in the EU, then you'd probably be in scope. And importantly for our industry, if you monitor the behavior, which is what Abby mentioned in the beginning of the presentation, if you monitor behavior of people who are in the EU, it doesn't matter where in the world you are also subject to the GDPR. So it's pretty wide in scope. All right, so then here's the question from Lorenza Chiaramonte, who asks if you can consent to cookies by scrolling down a page.
Okay, so once again, this comes back to my previous point about the e-privacy directive and implementation based on member states. So the Italian guarantee has specifically said that they consider acceptance through page scroll as valid, as a valid form of active consent. So it really depends on the member state. If you want to be the most careful possible, you can choose how you want to apply that. Standard is clicking a button and saying I accept, but you do have some leeway there, I guess, depending on the actual member state that you're targeting there. As I said, for a fact, we do know that the Italian guarantee allows it, but it might not apply on other member states. So I would probably recommend to take this into consideration.
The law requires an affirmative action without saying exhaustively what the affirmative actions are, right? And scrolling is affirmative. So to the extent that the scrolling is also unambiguous in meaning an agreement, then yes, which seems to be what the Italian DPA saying, however, I will add that many other DPAs are moving away from accepting what one could refer to as navigational consent. So if the user does certain things which are affirmative and they have been told that if they did those things that will be counted as consent, as not strong enough under the GDPR. Although, to be fair, in the past they have said that is good enough, even though arguably in the past we didn't have an affirmative consent requirement like we have now. So you could push back against that reasonably as well, legally speaking. But in order to mitigate your risk, it's probably smart to take into consideration what your local DPS says.
Actually, I saw a question there which could be quite interesting because it's very internationally focused, let's say. It's actually the last one we got. And the question is, if I read it out because it's a bit extensive, how do you think companies can best handle different global privacy standards? For example, CCPA in California or India's new proposed privacy laws may differ in requirements. Should companies simply aim to comply with the strictest laws, or pick and choose markets which laws they can comply with easier? This is, if I maybe start and then Abby can add to that, this is actually interesting because this is kind of one of the, it goes a little bit in line with what our beliefs are. So what we actually do is that we tend to, given that there are so many privacy standards around the world, I mean, what we tend to do is apply the strictest standards that we can find, so that if you would be in a country which has a bit more leeway, you would sort of still apply to no matter where your users are based. So this is actually one of the challenges that we saw in the market, one of the reasons why iubenda was actually founded. I don't know, Abby, if you want to add more to this.
Yeah, no, I think that basically covers it. Just to say that it's always easier to apply the strictest standards and then sort of customize to your needs than to do it the other way and then realize that users from a region with strict laws are accessing your site and then find yourself in some trouble. So I would also, along with Philip, say it's always a good idea to be aware of and to go with the strictest, keep an eye on the strictest laws by default. Matthias?
Yes. So let's talk about a different legal basis for once. We have had a few questions on consent, and here's another question by Barbara Radon, who's asking if hash names and hashed addresses can be processed on the basis of legitimate interest for targeted advertising.
Okay, let me just pull that right up here. Okay, so now the thing to consider here, and I'm not super great on all of the technical fronts in detail. I have a general idea, but I can tell you in regards to the law and legitimate interests, the thing to keep in mind is that there is that right to object, and also the legitimate interest does have to legitimately apply to your case, because if you are challenged on it, if the authority takes a look, you need to be able to actually justify using a legitimate interest in that case. So again, try not to think of it as picking, but try to think of the legal basis as what can apply to your case. And when it comes to advertising, what's one of those situations where the user does have a clear right to object if they so choose. So that's something to keep in mind. Maybe Matthias would like to add something here.
Yeah, so I'll give you the opinion of the Article 29 Working Party, or now the European Data Protection Board. It has said in the past, and I'm fairly sure they still hold that view, that legitimate interest is not available for what they refer to at the time as online behavioral advertising. They say that needs consent. Now, opinions, even those of data protection authorities, are just that, they're opinions, and you and I can have different opinions. And legally speaking, there is no exhaustive list of what can qualify as legitimate interests, so that it is completely unreasonable, in my opinion, to say that a specific purpose of processing could never be subject to a legitimate interest legal basis. In fact, we've had the Court of Justice come out very strongly saying you can definitely not say here is a list of pre-approved legitimate interests and something that can never be a legitimate interest. The whole point of the legitimate interest is that you as the controller, you think about whether you can process the data on the basis of the legitimate interest after having considered all relevant facts, after having weighed the interests of the data subject and their fundamental rights and your interests, and considering their reasonable expectations and so on and so forth. And that will just be an individual case-by-case assessment, and nobody will be able to say generally yes or no to that question. I think what is important to raise over and over again is that legitimate interest is not something that you can just say, oh, I have a legitimate interest, great, I don't have to worry about anything else. It's a lot of work. It can be more work than consent, and you can get it wrong. And if you do get it wrong, you're at fault for one of the greatest offenses under the GDPR, which is processing personal data without a legal basis. So you want to be careful. All right, so here's another very interesting question, which is, what about people who are changing location? What if a person is in the EU and is subject to the GDPR because of their location in the EU, and then they're moving somewhere else, maybe on vacation or permanently? What happens there? How are you supposed to figure out whether or not the GDPR applies?
So we slightly touched on this earlier, and I would say the thing here is it's really not feasible to choose whether or not to or to determine whether or not the scope applies to you based on the individual users accessing your site on a particular day. So I would say generally you'd want to go off of if people from the EU can access your site, then it's reasonable to assume that they will. It's a website, and if it's accessible and you're not actively blocking them, or you're not, let's say, some really local business. So this, of course, is only applying if you're based outside of the EU in the first place. But let's say you're a company based in India and you're doing, maybe you do like a delivery service specifically just to people in India, ordering food or something like that. Okay, this might be one situation where clearly your intended audience is not people in the EU. It's specific, it's a local business specific to particularly India. But let's say it is, you have a website and you do offer this service internationally, and people from the EU can access your site. In that case, then you need to just apply the GDPR protections to those people. It might be easier to implement on a general basis. It's up to you to choose on a technical side how you want to implement that. If you just want to extend those protections to everyone, which might even be a good idea, since some of the laws in the US seem to be moving towards stricter rules for data privacy. Of course, we're keeping an eye on this, but the choice there is really up to you. Now, one little pitfall you don't want to fall into here, and as Matthias mentioned earlier, is if you are monitoring people in the EU in any way. So you don't want to just have, let's say, some analytics type program just processing the data of everyone that accesses your site, even if you're only selling to people based in, let's say, India in the example. If you're still monitoring the behavior of all your site's visitors and that site is accessible to people in the EU, so you're also processing their data, then it's going to apply to you in that case. So this is one of those cases where if you want to be exempt based on only targeting users from a certain region, you want to make sure that your actual technology and implementation is in line with what your intention is, or else you might find yourself accidentally falling into the scope.
Cool. So we're nearly at the top of the hour. I think we maybe have time for one more question, and then it would be great for you to perhaps share how to get in contact with you and whether there's any other resources that people could consult if they have further questions to you guys. So last question is about record keeping for consent. So you mentioned the various requirements, and do you think that saving an IP address with a consent log should be enough to clarify who gave the consent, considering that an IP could be used by several people or be dynamic?
So generally what we recommend in terms of keeping records is keeping a dedicated sort of user ID. And of course, this is also in relation to the kind of consent we're talking about here, right? We're talking about general consent. Let's say someone's signing up to your newsletter form. We usually keep a record of, like we mentioned, the version and the particular legal documents that were available and in force at the time that the user gave their consent. Though this may or may not be specifically required, it's usually a good idea if you have it implemented on your site to indicate whether or not the person used double opt-in. It's usually a stronger indication that the person who gave their consent is in fact the person that wanted to have that wanted to be on your email list or wanted to have their data processed by you. Also a timestamp to again indicate that this is the time that the consent was collected, the time that you're saying it is, and that it also correlates with the legal documents that were available at the time. So these taken together is usually another one. So sort of all of these, and also of course a subject ID. So there's usually an ID for both the consent as well as the user. So it's one of those things where a collection of pieces of data can come together as a whole to better indicate or be able to demonstrate that you did collect consent in the right way, because the requirement here is to ensure that you can demonstrate that valid consent was collected. There are other things, of course, other pieces of information I'm sure you can add in, but generally this is in a point where you want to be lax and not have enough information to prove this, because obviously it can be an issue, and if you're not able to demonstrate that valid consent was collected, you're sort of rendering the consent that you've collected as invalid, because you won't be compliant if you're not able to demonstrate this. So I would say you want to go a little bit beyond just, of course, this depends on what your consent log contains as well. Just want to add that in.
Yeah, so essentially whatever you can get your hands on to demonstrate is good, but sort of this fear that perhaps whatever identifier you do have is not specific enough to a particular individual, it's still the best you have, and sort of the GDPR doesn't want you to go out and get more data for the sole purpose of complying with the GDPR. It's sort of against the concept of data minimization and so on, right? So
yeah,
we're at the top of the hour, so I want to just thank you one more time for coming on and presenting and answering so many questions. You have some email addresses here on the slide. Again, the presentation will be shared with you, including the recording of this webinar. But Philip and Abby, would you like to say a few words at the end and perhaps guide viewers to where they can find additional information, in addition to, of course, IAB Europe's website, where there's also some resources.
Yes, Philip will also get a little bit more into that, but I'm also, while he's explaining, I'm also going to link the GDPR guide that we have that sort of covers a lot of what we spoke about.
Yeah, exactly. So Abby, so I can actually do it at the same time. So you can, we have a very extensive GDPR guide, because obviously we could not go into every single detail today. We've just shared the link here, so there's a lot more information there. And if you want to get in touch with us, you probably saw the email on all the slides, but it's simply info@iubenda.com. We have a very good support team. We've also just shared that on the chat, and from there you would be then redirected depending on the type of question you have. Is it more a legal question or a product question? And finally, since people were asking, they wanted to see our product live, we obviously also have our own webinars where we go more into actually live demo and taking you step by step how to do all this, such as creating a privacy policy or setting up a cookie solution. So we also just shared our webinar overview. And yeah, so thanks for all the questions. Thanks for inviting us, Matthias. And
thanks for coming, everyone.
I guess we are we are a little bit over time now. I don't know if you want to add anything, Matthias.
No, just thanks. Tune in next time. Thank you for coming. Bye-bye. Have a great day.
Thanks, guys. Bye-bye.
Bye.